Fixing monetary limit of income tax authorization, respect of reduction and waiver of interest. Section 2 clause 22 imposed interest in taxpayers for delaying the payment of tax for the demand notice issued from 156 rate to 1% per month as per the month of the per period of delay. However, Section 222 A certain authorities are imposed to reduce the waiver of interest in specific conditions are met as per circulars of CITN or CIT have waived the interest amount up to 50 lakhs up to by the chief commissioner or TGIT can handle the amount exceeding 50 lakhs but not exceeding 1.5 crores and this authorities amount to 1.5 crores. Circular 152/2024. Supreme Court liability for bankers to allow operation of lock restriction income tax department. So HDFC will state of Bihar Supreme Court judgment. Similarly, arose this case of HDFC branch allows a bank locker to be operated by the Kahima family on whom a search was earlier conducted on their bank account and lockers are restrained by the Director of Indian Income Tax. However, subsequently the said restraint order was revoked through only the relation to bank account. However, the order official banker interpreted that the revocation of his application for the locker also allow the locker to be operated. The Supreme Court, by considering the appeal of High Court that the FIR did not mention prima facie case of offences being made out by the bank official, which they were nothing to show malfida, thus allow the appeal squash the FIR against the bank official.
GST guidelines for conducting a personal hearing under the GST Customs Officer to revise the previous instruction concerning mode of personal hearing under the various Act, including GST and Customs Act and Adjudicating and Appeal Authority. Amendment Section 28 July allow personal hearing to be conducted in virtual mode only upon request of the assessee. The physical hearing is an option for those who did not upload via virtual hearing. However, the amendment has now been withdrawn, restating the original instruction that mandates a personal hearing must be conducted through video conferencing. Physical hearing may only occur at the respect of the party involved. The requirement document as a reason of the request. Minister of Finance instruction dated for 5/11/2020. Advisory time limit for reporting invoice of IPR portal lower threshold of turnover 10 crores and above. As per the yearly advisory dated 13 September, as time limit of 10 days for the reporting invoice of IPR portal of taxpayers and the annual turnover 100 crores and above implement. This threshold has now been lowered to cover taxpayer 10 crores and above for the 1st April 24. And you have to apply for all the documents, invoice, credit notes, debit notes, and IR has been generated. Advisory for Form GST DRC 03 was demanding payment of adjustment. GST has launched on DRC 03 addressing the issue arising from the taxpayer pay outstanding demand using the Form DRC 06 rather than the payment towards demand. Feature the GST portal when the DRC 03 has been incorrectly. Electronic liability register do not register the demand is closed. Even though the portal has been made to resolve this, the Form DRC 03 has introduced under the notification number 24 issue under the 20th July. The form allows the taxpayers to link the payment from the DRC 03 where the reason for the payment is make voluntary others. Directly a specific demand notice. As a DRC 03, taxpayer must enter the application reference number on the DRC 03 along with the relevant team demand notice on our portal. The detailed advisory FASQ has been provided and GST portal to guide the taxpayer through this process. Advisory related to other territory application and for registration. Advisory of GST registration under the other territory category applies to application located in India, continental and exclusive economic zone along with the western and eastern coast. As such application shall only be administered under the Mumbai Code, Mumbai South and South North China Commissioner. This applicant must select the jurisdiction based on geographic proximity for the nearest western coast, covering the Gujarat, Maharashtra, and neighboring country for Mumbai coast, deciding Commissioner of Mumbai South. Similarly, the application near the eastern coast, nearly West Bengal, Tamil Nadu, and our surroundings, and judicial falls under the Chennai North Commissioner. This appearance should be selected appropriate division range. This is originated alphabetically by the first letter of the name of the US number. Advisory of waiver scheme of GST taxpayer under section 128. The waiver scheme of the taxpayer has been introduced by reducing the disputes of waiving interest and penalty and demand order section 73 of CGST Acts Grants Act 1918 to 1819 or 1920, including the case involving fraud of willful misstatement. To avail this waiver, taxpayer must pay the full tax amount by 31st March 25. And notification of 2024 on 8th October, the rule 9164 with outlines the procedural guidelines of that waiver scheme. The taxpayer is required to first file the application in the form GST space PN01 and CGST SPN01, the common port of decline for 31st March. These forms will be available by the first week of January. It is a meantime taxpayer should ensure payment of demand tax using payment towards demand facility. Okay, use of demand order GST authority in case of notice. The payment is already made using a DRC KCC. Taxpayer must leave the demand order through the GST away on the portal.
The High Court no GST liability and salary paid to the second employee as per CP sector is Metal One Corporation of India of India. The High Court Delhi Judgment 22. The foreign entities are also the liability to pay GST on salary paid to the second employee for government service. Written would have been treated as email with the CBS circular. Once a portion of CBS circular is from all the on the basis of parent and income. The penalty proceeding as imposed of interest will not be sustained. The High Court of Delhi judgment on 21/2021. Second was two immigration officer on the same period is not observed. Jain Samudra the petitioner of the Jain Samudra which covered the Pachian 13th September December. High Court to GST adjudicating order of the same period is not permissible. So Jain Samud Ayodhya Youth Adyo sales tax officer High Court of Delhi judgment. Petitioner Jain Samanyodhya was served as a show cause notice to 30th December for the same tax period, processing cumulative in the final order passed in 1st January. The petitioner subsequently filed an appeal against the 31st December 2021 decision. However, despite of the finalized 2021 order, second order on the April was issued referred to the same tax period based on the original show cause notice. In 2020, the court took a note of the discrepancy between the prior decision and the new order, questioning the validity of readdressing the same issue. The Delhi High Court, however, petition thereby providing the relief to Jain Samanyodhya. However, the judgment does not affect any rights or contention relating to the initial 2021 order, which remains under the appeal. High Court of IGST on the ocean freight could not be leaved for FOB transit in cases BLA, Coke and Union of India. High Court Gujarat judgment dated exactly. The company was engaged in manufacturing sale of hard coke, which imported cooked coal of a CFF cost insurance freight and FOB basis. Assessee argued that while CFF assessment includes freight costs and the consultation invoice raised by the exporter for an export. The free board transaction. The freight was paid directly by the assessee to the shipping line. Importantly, the IGST was paid on the total value of import, including freight at the time of customs clearance. The High Court held that IGST on the ocean freight could not be levied on the FOB basis. Transaction also, as once the IGST is paid on the value of goods, including the freight cost and insurance, it will not be made difference between the transaction only CIF and FOB basis. So it goes Gujarat judgment. Central Access No Notification, Customs Duty, Amendment Handling Cargo, Customs Area Regulations. The licensing terms of Customs Cargo Service Provider under the Regulation 5.3 reducing the 10 years of changes Regulation 10 to introducing a provision of CCSP operation under the authorized economic operator. From CCSP appointed shall be deemed to be extended to remain valid and long after EOE authorization valid is not suspension at revoked. Classification of insurance amount, bond value of CCSP, and validation of bond of EAUO. Cycle reduce the insurance amount considering the average storage period of 5 days from the entirely 10-day period. It's based on the reduced dual line importing and export goods as well as the effort to reduce operation costs of customs cargo service provider. Besides, the circulars amend the validity of custom bonds and authorization economic operator, low risk CCSP aligning with the validity of EOE order authorization. Anti-dumping duty of the welding stainless steel pipes, tubes originated and export from Thailand and Vietnam. Anti-dumping duty has been imposed on the import of welding stainless steel pipes and tubes originated in and exported from Thailand and Vietnam import to India. It shall be applicable for the period of 5 years.
Director General Foreign Trade (DGFT), by enabling the provision of import of imports that is subjected to mandatory quality control orders for advance authorization (EOSCC). The public notice updated the list of ministries and departments except from mandatory quality control orders for inputs. It's added to the Ministry of Heavy Industry Appendix 2Y of Foreign Trade Policy, which outlines explanation of the goods utilized for manufacturing exports. Securities Exchange Board of India, investment in overseas mutual funds, unit trust of India mutual funds. The circular allows the Indian mutual funds to invest in the overseas mutual fund and unit trust and specify those with exposure of Indian securities subject to certain conditions. Investment is an overseas mutual fund unit trust cap to 25% of the total asset of Indian securities. This requirement is pooling the contribution of overall investors, ensuring the buying pool structure without segregating portfolios and managing the fund through the individual managers. Besides the oversized entities on disclosing the portfolio quarterly. Disclose of expenses, half-yearly returns, yield, risk to return manner. The circular requires mutual funds to disclose separately total recurring expenses, half-yearly returns, and yield directly and regular plan. Effective on 5th December. Besides the risk meter, which includes a risk of level of mutual fund schemes, which is now incorporated in a color scheme to enhance the clarity of the investor. This color designation range of low risk to very high, changing the risk level, must be communicated in the unit holder. Notice the email or SMS with both previous address covers enclosed comparison. Advisory and unauthorized virtual trading gaming platform. This advisory related to unauthorized virtual trading platform, including webs and applications that offer virtual trading, paper trading, or fantasy gaming services based on stock price data of listed companies, which activities violate the Security Contract Act 1956 and SEBI Act 1992, which is designed to protect the investors. Advisory emphasizes that the public should only engage in the trading that's registered intermediates and caution that participants in the unregistered scheme is in various investors' own fund. These unauthorized platforms are not recognized by SEBI, and thus investors will lack access to investor protection scheme and grievance addressal program SEBI F Exchange. Advisory Committee of SEBI official. The advisory classifies that informal discussion, summaries, and meeting minutes meant by the entities of SEBI should not be interpreted as official approval, clarification, security, market, and operation issue. SEBI emphasizes the entities should proceed the implementation measurement having SEBI approval only after receiving explicit written authorization clarification of SEBI. For inter-perspective or policy-related queries, entities are advised to use the SEBI informal guidance scheme 2003 and formally request interpretive non-action letters. And conclusion papers on measure of forms of debentures, trusting and regulation, including towards easy doing business. The key process including establishment activities, population DT, class default, standardized and debenture trust DTTO. The aim is separate non-SBI regulatory activities from the government of SBI. Ensure that DTO do not misrepresent the regulatory status. Comment from the stakeholders are invented. Consultation papers are review of requirement of alignment interest on the designated employee of AMC interest and unit holder. The consultation focus on the skin and game requirement. This mandate the AMC employees to invest in portion of the compensation in mutual funds unit they overseas. This working group is raising concern about the impact of current requirement of 20% investment, particularly employees with lower salaries, as well as a challenging pose of including non-cash components of employee stock ownership plans. This paper proposes to reduce the mandatory investment state percentage and exclude the non-cash components about the calculation. This remuneration is calculated the slab-based system, whereas the minimum investment varies from the employees with the adjustment of employees and significant non-cash component. This component of stakeholders are invited. Consultation papers on proposed review of definition of unpublished price sensitive information UPSC under the prohibition of introduced trading. The proposed alignment of UPSC defining the events under the regulation 30 SEBI listing obligation and disclosure requirement regulation emphasizes the material even though they are offset the stock prices. SEBI study prevails that the companies are limited UPSC items related listed in PPIT regulation. Missing border compliance item. This proposal are intended to enhance regulatory clarity and consistency and compliance along the listed companies. These comments or stakeholders are invited. Minister of Corporate Affairs notification, Insolvency Vacancy Code of India discussion paper on mediation of operational creditors before approaching adjudicating authority for filing Section 9 application. Paper highlights that a significant number of Section 9 application involves disputes between operational creditors and corporate debtors over the issue of quality of goods, contract terms, payment discrepancy. Many of the cases were settled before the admission, resulting in only in fraction proceeding to insolvency. By promoting the pre-filing mediation, IBBI aims to ease the executive authority is slow to address disputes more efficiently. Under the proposal, if the mediation fails, no settlement report should be accompanied or insolvency application of AI. This approach intended to streamline the resolution process, reduce the judicial delay, and facilitate quicker case admission and comments from the stakeholder involved. Discussion papers on issue related to real estate. The key proposal includes mandate participants of land authentication or inviting the committee auditor meeting to improve the decision making and land related issues, establishing protocols to cease with the cancellation of land allotment, clarifying the condition of authority associated with the participation of resolution application. Besides, the paper suggests the including 8% interest on home buyers, claiming the consistency across and allowing facilitation to represent large creditor class, and improving communication by sharing OCC meeting minutes with all creditors and real estate project. This proposal seeks to address proposal gaps, improving transparency and strengthen creditors representation and commitment of stakeholders and investors. Supreme Court laid down legal framework, withdrawal settlement of claims of the CIRP while advocating Byju's matter. The GLAS Trust Company is Yujo Ravindra Supreme Court. Supreme Court emphasizes the need to allow the legal framework to lay down by statutory provision with withdrawal of the petition and settlement claim for corporate insolvency solution process. It was stated that Chapter 2 of IBC provides that CIRP was invoked in three ways: financial creditor Section 7, by the operation creditor Section 9, and corporate debtor itself Section 10. Section 511 of IBC default initiate debts, data financial creditors, operation creditors, and corporate application make application of NCLT initiate insolvency proceeding in CIRP upon the address of application. CIRP commences moderate, declared, and insolvency resolution professional. The application appoints who manages all the further affairs of the corporate debtors. Further, the claims are receive all the creditors they are allotted, determine the financial position of the corporate debtors, and commitment Committee of Creditors. The NCLT is exercising the inherent powers under the Rule 11. These NCLT rules are revoked by the Supreme Court, stating that when the procedure has been prescribed for a particular purpose of exhaustion, no power shall be exercised without the matter of prescribed in the state provision. The correct manner of scope is approval of a settlement, source of fund, and settlement NCLT, which will be stayed in the consultation FCOC, and direct parties follow the course of action. Section 12A, read to the Regulation 30A of CIRP Regulation 2016. Reserve Bank of India amendment of the Master Direction known to Customer Direction. It of the Master Direction is a new Customer Direction. February 25, 2016 held that regulation entities have to undertake the consumer due diligence as per the provision laid on there. And the customer key amendment provision, the customer acceptance policy allows the simplified customer due diligence and existing customers to operate additional accounts and obtain a new service. Besides the period of KYC updation process, they clarified a new requirement of updating KYC records of central KYC register has been established. The specific how the regulation introduced will handle the KYC information and revise process including use KYC identification. Fully accessible route of investors and non-residents in the government activities. The inclusion government green sovereign green bonds RBC expensive fully accessible route, including 10 years sovereign green bonds of non-resident investors. This inclusion sovereign green bonds allows the issuance calendar for the marketable debt securities October 24-25. It enables the non-resident investor to contribute a sustainable financial within the year and invest by the designation green projects. Reporting foreign exchange transaction of trade policy practice. These master directions are risk management interbank rails of the dealing. This means allowing dealers to report all the over-the-counter foreign exchange derivative contracts and foreign currency interest derivative contracts. This is undertaken by the directly and thereby overseas entities, including overseas branches, IFC banking units, wholly owned subsidiaries, and joint venture authorized dealers. So the trade depositories of clearing corporate of India being discussed in the expansion reporting requirement, including foreign exchange and deals with the phasing manner, inclusion value, cash and value done. For the FX contract of clients are reporting the phase of starting 12 2025 transaction over USD 1 million now but 10 million to 2025 for transaction over 50,000 USD. However, money exchange transactions remain outside the scope. RBI notification. Miscellaneous and Supreme Court royalty and advertisement holding cannot be equated with the imposition of tax against the Patna Municipal Corporation and Tribunal at Bureau Supreme Court. The apex Court, 16th October 2024, Apex Court said that the imposition of royalty could be equated to the imposition of tax levy. Municipal corporation to be charged royalty of 1 square feet per year for holding display of a land under jurisdiction. This corporation introducing a new royalty rates or advertisement setting a different rate to various type of voting. The rate is increased to 10 square feet per year for this responded. This corporation passed a resolution to cancel the registration of advertising agency for the enhancing royalty payment after discovering illegal hosting and unpaid dues. The demand of the royalty fees and tax were issued on advertising companies based on this solution. Yeah, the deviation bench of Patna High Court is applicable therein could not raise any demand in tax royalty adjustment since has been without legislation sanction and thus the violation of Article 256 Constitution of India. It is further directed that all the amount recovered by the appellant thereunder the count, that is, pay of tax and advertisement refunded to the concerned parties. Also, the consequence that would be no question of imposition of penalty. And expressing royalty is and consistently being constructed to the compensation paid to the rights and privilege enjoyed by the guarantees. Normally, the genesis of agreement entered into between the creator and createe as an against a tax which is imposed upon the statutory power without the reference to then specific special benefits to the arrangement between the parties and normally as a direct relationship with the benefits privilege conference upon the guarantee. The Supreme Court held that the decision of the corporation to take 10 rupees square feet regarding the holding advertisement is communicated at the relevant point of time to the concerned parties need to be interference. However, the imposed on the penalty of non-payment of due interference will be no such proper tax. It is held as a clarification conveyed the corporation will be precluded from the charge changing the interest over the delay period. Obviously, interest on the delay payment could not be a penalty, but rather a rearm of compensation late fees and amount is payable under the earlier. Disclaimer: this content of articles are the information purpose only. This user can refer to the relevant notification circulars issued by the respective authorities for specific interpretation and complaints related to the particular subject matter. Thank you.